Hello friends, welcome to Police-Based Loksewa. On this series, I'm presenting Nepal's legal arrangements for bilateral relations. On this episode, I'm presenting the Treaty of Extradition between the Government of India and the Government of Nepal, 1953. So let's begin the Treaty of Extradition between the Government of India and the Government of Nepal, Kathmandu, 2nd October 1953. The Government of India and the Government of Nepal, being desirous of regulating extradition of criminals as between the two countries, have resolved to enter into a new treaty of extradition with each other and have for this purpose appointed as their plenipotentiaries the following persons, namely the Government of India, His Excellency Sri Balchandra Krishna Gokhale, Ambassador of India in Nepal; the Government of Nepal, the Honorable Sri Matrika Prasad Koirala, Prime Minister of Nepal, who, having examined each other's credentials and found them in good and in due form, have agreed as follows. Article 1. The two governments hereby engage on a basis of strict reciprocity to deliver up to each other those persons who, being accused or convicted of a crime committed in the territory of one government, shall be found within the territory of the other government under the circumstances and conditions stated in the present treaty. Article 2. Neither government shall be bound in any case to surrender any person who is not a national of the country by the government of which the requisition has been made, except where such person is accused of having committed the offense specified in clause 10 of Article 3, which is desertion from armed forces. Article 3. The offenses for which extradition is to be granted in accordance with this treaty are the following, namely: 1. Murder or attempt or conspiracy to murder; 2. Culpable homicide not amounting to murder; 3. Grievous hurt; 4. Rape; 5. Dacosity; 6. Highway robbery; 7. Robbery with violence; 8. Burglary or housebreaking; 9. Arson; 10. Desertion from armed forces; 11. Offenses against the laws prohibiting the export and import of goods; 12. Embezzlement by public officers; 13. Serious theft, that is to say, cases of theft where violence bar been used or where the value of property stolen exceeds Rs. 500, and cattle stealing; 14. Abduction or kidnapping; 15. Forgery and the use of what is to be forged, counterfeiting or altering money; altering or bringing into circulation counterfeited or altered money; 16. Receiving of illegal gratification by a public servant; 17. Escaping from custody while undergoing punishment after conviction for any of the offences specified in clauses 1 to 16. Article 4. In no case shall either government be bound to surrender any person accused of an offence except upon a requisition duly made by or under the authority of the government in whose territories the offence is alleged to have been committed, and also upon such evidence of criminality as, according to the laws of the country in which the accused person shall be found, to justify the apprehension and sustain the charge if the offence had been committed there. Article 5. Neither government shall be bound to surrender any person if the offence in respect of which the surrender is demanded be of a political character, or if he proves that the requisition for his surrender has in fact been made with a view to trying or punishing him for an offence of a political character. Article 6. Extradition shall not take place if the person whose extradition is claimed by one of the governments has already been tried and discharged or punished, or is still under trial in the territory of the other government for the crime for whose extradition is demanded. Article 7. If the person whose extradition is claimed by one government is under trial for any crime in the territory of the other, his extradition may be deferred until the conclusion of the trial. Article 8. A person surrendered shall in no case be detained or tried in the territory of the government to which the surrender has been made for any other crime or on account of any matter other than those for which extradition has taken place until he has been resorted or had an opportunity of returning to the territory of the government from which he was surrendered. Article 9. If the evidence sufficient to justify the extradition is not produced within 2 months from the date of apprehension of the fugitive, or within such further period as may be allowed by the government to which the requisition for extradition has been made, or by the court before which the evidence is to be produced, the fugitive shall be set at liberty. Article 10. The expenses of any apprehension, detention, or surrender made in pursuance of this treaty shall be borne and defrayed by the government making the requisition. Article 11. The treaty supersedes and cancels all previous treaties, agreements, and engagements on the subject. Article 12. These treaties shall come into force without ratification 1 month after the date of signature by both parties and may be terminated by either party by giving 1 year's notice, done in duplicate at Kathmandu. This 2nd day of October 1953, Balchandra Krishna Gokhale for the government of India and Matrika Prasad Koirala for the government of Nepal. So this was the end of Nepal-India Extradition Treaty 1953. Please do like, share and subscribe this channel for regular updates like this. Goodbye.